Hello, my name is Joshua Thompson. I'm a staff attorney here at Pacific Legal Foundation. I'm here today to talk about a recent victory PLF had in its case of Connerly versus State of California. The story of this case starts last summer when the legislature passed Assembly Bill 21, which required and mandated 15% and 5% quotas for minority and women business enterprises in public contracting. In other words, when the state was to buy equipment or materials for other projects, this law required them to seek out 15% of the contracts for minority business enterprises. PLF, on behalf of Ward Connerly and American Civil Rights Foundation, challenged this law, saying that it was unconstitutional under Proposition 209. Proposition 209, of course, is California's landmark constitutional amendment that prohibits discrimination and preferences in public contracting. And PLF argued that this newly passed legislation was in violation of Proposition 209. The interesting twist in this case came when the state agreed that the legislation that it was passed was unconstitutional. But the state argued that the court should not declare it unconstitutional because it had the power simply to not enforce the statutes. PLF, not satisfied with the state's assurances, asked the court to issue a writ of mandate requiring the state employees to refuse to enforce the unconstitutional provisions of the statute. In other words, PLF maintained that the court had to declare the statutes unconstitutional. Well, on July 2nd, the court agreed with PLF and declared the statutes unconstitutional and issued writs of mandate prohibiting the state from enforcing these unconstitutional statutes. Now the state has 60 days to appeal the decision, but for the time being, it is an excellent victory for Californians' rights to be treated without respect to their race or sex. Thank you.